Okay, greetings to those of you who are joining us. We will start in a minute or two, just waiting for some people to join us. And also greetings to those on Facebook. Right, greetings to everyone. Professor David Bilchards, Director of SciFac. Great to have you all with us. We welcome both those in the room with us and those who are joining us on Facebook for this exciting seminar on children's rights. This is part of the Human Rights Festival, an extension of the Human Rights Festival of Constitution Hill. So we welcome those of you who joined on the weekend for the events and also in commemoration of Human Rights Day. Our chair for today will be Thandeka Khoza. Thandeka is a researcher at SciFac, and she has put together the seminar. Thank you, Thandeka. We very much look forward to the seminar. So I'm going to hand over to you just to mention that we've got a number of interesting seminars coming up, hopefully in April and May. Particularly at the moment, we are looking at engaging with the terrible law that was passed from a human rights point of view against the LGBT community in Uganda. And so we will have a seminar discussing that. But without further ado, not to preempt us, but to focus on our day, we're going to focus on children's rights. And over to you, Thandeka.
Thank you, Prof. Good evening, everyone. So as Prof mentioned, tonight's seminar focuses on children's rights. The title of the seminar is Where Are Children's Rights Headed in South Africa? Sorry about that. So we are going to focus on some recent judgments reflecting on child rights, judgments handed down by the Constitutional Court. And then we're also going to have a look at or chat about some jurisprudential trends and themes which emerged from the recent judgments of the Constitutional Court. And then we're also going to have some discussions tonight on South Africa's reporting trends and the implementation of concluding observations given to South Africa by the African Committee of Experts on the Rights and Welfare of the Child, as well as the UN Committee on the Rights of the Child. So we've got 3 speakers this evening. I'll introduce each one just before they start speaking. And I'll start with our first speaker, which is Dr. Elvis Fokala. Dr. Elvis Fokala is a child rights and public international law in Africa expert who holds a PhD from Åbo Academy University in Finland. He's the manager of the Child Rights Unit at the Center for Human Rights, which is based at the University of Pretoria. And he's also the president of the African Network of Constitutional Lawyers. So Dr. Fokala, over to you. Thank you.
Thank you, Thandeka. Thanks to Prof. Bilchards as well. Thanks to SciFac for organizing this event. And I say hello to all my colleagues with whom I'm sharing the platform with. And also extend greetings to all those who are joining us on the different platforms on which we have been connected to for this very important conversation this afternoon. My interest in this conversation is just to lay out a trend of what is happening at the Constitutional Court of South Africa, just to break the dice for us to understand the extent to which the Constitutional Court is going to protect children's rights. I'm aware that my colleague Stanley will also deal with some contemporary issues. But what comes to mind is that if we look at the attitude of the Constitutional Court recently, And if you want, you can go back to the days when we had Justice Richard Goldstone on the bench and all whatnot, and the S&M case. If you go right back to some of those cases, you will see that the last 10 years, the Constitutional Court has been very intentional in its decisions. In my opinion, and when I look at the cases that the Constitutional Court has decided on for the last 10 years, is that the Constitutional Court seems to have adopted, in a way, an activist approach in the way that it tackles some of the issues that relate to children. It comes back to me as a situation of we are tired. We would like these issues to be resolved. And some of those issues are the issues that I'm going to highlight. I have grouped my conversation in 3 different areas or cases in which I think the Constitutional Court is trying to pass a very strong statement. These are issues that have existed in South Africa either before the previous system of governance in the country, and even to now, we still have these systems of governance or these provisions in our laws that have continuously put the child on the back foot of being protected. What the Constitutional Court has done in the cases that I'm going to highlight is the fact that it's trying to repeal those laws or those sections in the various provisions that I'm going to quote as well, that it thinks or has analyzed and believes that these laws are repugnant to children's rights and to natural justice and all whatnot. So in that context, I'm going to look at 3 different aspects, 3 different cases, very briefly, succinctly, for the 15 minutes that I have, for the time that I have. The first one is a protection of a migrant child's right to family life and to protect children against statelessness in South Africa. That's the first situation that I'll look at. The second would be to look at issues of moderate, and this word moderate or reasonable chastisement is a way of phrasing chastisement generally around children, but it's a way of saying that what I'm meting on the child is a reasonable and a moderate way of chastising the child. But we have this second trend of protecting a child. And the third will be to provide, or the Constitutional Court decision that granted the right to unmarried fathers, to give notice of the birth of a child. In these 3 instances, what you pick across all 3 is that what the Constitutional Court is trying to do is that the Constitutional Court decisions it plays out as a commitment to avoid or to protect children from being exposed to risk, or to protect children from being exposed to further risk in a country where children continuously suffer either from the actions or the inactions or the misgivings of their parents, of the society in which they live. In a country where they could easily be affected by so many other things that happens across the country. In the first case that I looked at, that's the case of Nandutu. This is a 2019 case. And all the cases that I'm going to mention are very, very recent cases, 2019, 2019 again, and then the 2021 case. In Nandutu, from the face of it, Nandutu is not a children's rights case. If you look at it, you will say it's not a children's rights case. It's a case that seemed to invalidate Section 9 sub 1, or Section 9 sub 1 of the Immigration Act, which allowed foreign nationals in South Africa to go back to their country in order to get the valid permit to revert to the country. But if you read deeply into Nandutu, you will understand that the decision of the High Court was, of course, speaking in that lens, which is speaking to the adult world, but the decision of the Constitutional Court sort of, and in a way, moved away from protecting the adult who brought in the case, but to protect the child in that case. Nandutu came from Rwanda to visit her fiancé in South Africa, pregnant, and while in South Africa, she wanted to change her permit, but couldn't because the law says she has to go back to Uganda to change this law. But while she was here on legal advice, she got married and had a child in the process. And now to register the child, the father could not register. And this is where you see the link to the last issue that I will deal with. The father had a permanent resident permit, but the father could not register and the father was a British national who resides in South Africa on a permanent residence permit. So what the Constitutional Court reasoned in that case is that if the mother had to go back to Uganda in order to have a permit, then the family will have to be, the family life of the child would have to be violated because they have to move back. The argument that most people have made, and I've also made in some forums or in some publications, is that there is that possibility that the child could have been left behind to stay with the father while the mother goes back to renew her permit and revert or come back to South Africa. But that was not the crux of the issue. That was not the crux of the issue. The interest of the Constitutional Court in that case was to protect the family unit, was to protect the child's right to family life. And I move very quickly to the second case, and because we will discuss all these issues when we get to the end of it. The second one is on the issue of moderate or reasonable chastisement, which is also a case that the Constitutional Court handed judgment down on in 2019 as well. Now, in that case, for most of us who follow jurisprudence, we understand that a child, 13-year-old, was watching pornography, and of course, it was not in accordance with the parents' religion. So in other words, the father had to, chastise the child, and what they ended up defending in court as reasonable and moderate chastisement in order to correct or to correct the attitude or the behavior of the child at a particular moment. What I actually like about this case is that some of the pointers that the applicants or the defendants, the parents brought into this case as the defense for their attitude towards the child was that, one, it was a corrective measure, that the child shouldn't do anything that is or that violates their religion and things like that. And then two is the fact that as parents, they have parental authority over the child and to guide the child further. Granted, but at the same time, the family space, which they also argued was a private space, in my opinion, is not absolute. It's not absolute because we still have the state. The state governs and the state is allowed to enter into the private space or into the family space when the right of the most vulnerable in that space is at risk. And in this case, we had a child whose rights were being abused with moderate or reasonable chastisement. The court went further to indicate that there are other ways of correcting a child. And this also plays out in the continent, right across the continent. And yesterday I was joking in class, and I was saying that one of the reasons why Africans and all of us from Stellenbosch to Cairo or from the Gambia right down to Juba in South Sudan, why most of us go late to events is that some of us, when we got beaten for coming late, it did not work. And it didn't work because that was not the right way of correcting us, of correcting most people in this continent about that particular act, which was not correct. So there are other ways of correcting a child without meeting what was called in this case moderate and reasonable chastisements. But these are conversations we can have when we get into the question and answer session. The third and the last case that I really want to look at, and which really, for me, was a groundbreaking case in which all of them are, but this to me stood out in a way, in the sense that first, the Constitutional Court declared Section 10 of the Birth and Death Registration Act 51 of 1992 invalid. Now, this particular section did not permit unmarried fathers to give notice to register their child's birth. What the Constitutional Court did in this case is that it granted that permission by declaring this section of this act invalid or unconstitutional. I like the way the Minister of Home Affairs or the Directorate of Home Affairs in this case, and in most cases you have Home Affairs involved in. But in this case, what Home Affairs did, which I found very interesting in my mind, is that they sort of agreed with the invalidity of Section 10. They agreed with the reasoning of the court. In other words, they've now come to the agreement that unmarried fathers can also register their children or give notice the birth of their children. What does this mean? If you look at this case and you look at the first case that I mentioned on Nandutu, is the fact that in the absence of a proper birth registration or giving birth or giving notice to a birth of a child could easily lead this child to a situation where the child has no documentation, a situation where the child is not recognized in the country, a situation where the child does not make it up to the civic registry as an addition to the country's population. We are in a country where the country does not have any plans or any legislation on issues of statelessness. And I think that through this method that the Constitutional Court has applied in some of these cases, and those that are still in front of the court at the moment, is that the Constitutional Court is aware of that gap within our Constitution to protect or to safeguard stateless people or children in South Africa by making such legislations or such decisions which in a way will provide some remedy for those who are found in this situation. Thank you so much.
Thank you, Dr. Fokala. That was very informative. And while you were speaking on the Nandutu or reflecting on the Nandutu decision, it made me think about another matter that's currently sub judice, which is Center for Child Law versus ST and others. And it also has to do with, has to do with migrant rights. No, I'm sorry, it's not that one. I'm lying to you. It is the Teresa Raymond and others versus Minister of Home Affairs, which also has to do with, the child of a migrant in South Africa and the migrants having to move. So we'll see if the Constitutional Court follows the same line of thought in that matter. But it was only heard this first term this year, so we'll see. But thank you very much. We are now going to have Stanley, who is from the Center for Child Law. And Stanley Malematja is an admitted attorney of the High Court of South Africa and practices as such at the Center for Child Law. And he is also a lecturer at the Department of Private Law at University of Pretoria. He lectures particularly child law and social welfare law. So thank you, Stanley. You can go ahead if you're ready.
Thank you very much, Tandega, for that introduction. And thank you again for making the space, allowing us to come and discuss the rights of one of the most vulnerable members in our society. And thank you, Dr. Elvis, for laying the foundation. It's always easier when someone goes before you so that they lay the foundation properly. And I mean, before I start with my presentation, Dr. Elvis, just to reflect on I think the last case that you mentioned regarding Section 10 of the Birth and Death Registrations Act, although in court there was a victory, is that, on the ground we are facing a lot of issues, because what the Department of Home Affairs has now in turn done is that it has published a circular, and according to that circular, before an unmarried father is allowed or can register the birth of their child, what the Department of Home Affairs does is that it requires a paternity test, and paternity tests, the last time I checked, it's nothing below 3,500. And, this case, speaks to the most, destitute in society. The father is unemployed and they're supposed to, get 3,500, God knows where. And we know the issue with, DNA backlogs in the government system. So we are faced with yet another problem when it comes to, just implementing the court order. But yes, it was a victory, in court. But Home Affairs has provided us with another barrier that we are in the process of fighting. So in my presentation, I will be focusing on what we in the Center for Child Law, we've termed the Dacha case. So quite a controversial case, but the Center for Child Law is not a stranger to controversy, especially when it comes to protecting and promoting the rights of children. You'd remember, I think in 2015, we litigated in the teddy bear clinic case, and the following morning when the judgment was out, there were newspapers all over Pretoria that the Constitutional Court says children must have sex, or that children must kiss each other, and that was not the case. So even with the Dagga case, when the judgment came out, is that, they say now the Constitutional Court says that our children must smoke Dagga. So, I think it's important that when we talk about this case, we first discuss what the case is not about before we jump to what the case is about. And from the outset, the amicus, Center for Child Law was amicus when the case started. Then we are the ones then who proceeded and took it to the Constitutional Court. So it is important to note that all the parties in the matter, they were in agreement that the case is not directed at allowing children to consume cannabis. So the case was not about the legalization of cannabis by the use or possession of children. Rather, the case was about decriminalization for the sake of prevention, and not to criminalize children for a conduct that adults are not being criminalized for. So basically what the Center for Child Law is saying is that the criminal justice system is not the appropriate system to respond or to deal with children who are found in possession of cannabis or who are found to be addicted to cannabis. So this matter, it has its genesis in 4 matters which were before the Krugersdorp Magistrates Court. Those cases were all on special review. So 4 school children, they were tested for drugs by their school. No permission was sought from their parents to run the drug test. So they were tested, and these children were found to have cannabis in the urine. That's what the test provided. So now the prosecutor decided on his own accord that they're going to send these children for diversion. So in all 4 cases, the children did not comply with the diversion, and there was an order that sent these children to the Mogale Liseding Child and Youth Care Center in Krugersdorp for an indefinite period. So you have children who have, they have an issue with a drug, they are hooked up to some form of a drug, but then what does the prosecutor do? Puts them on diversion, they fail the diversion, then they lock them up, and indefinitely so. So there was no period of release that was put in that order. So now when we went to the court, the fundamental question that arose, it was the Prince case, and the question that arose was whether the children committed an offense at all. And this was when, the court started interrogating the provisions of Section 4 of the Drugs and Drug Trafficking Act 104 of 1992. And, this provision was declared to be inconsistent with the Constitution to the extent that it criminalizes children for use or possession of cannabis. And now the problem with this situation is that the criminality attached to the conduct of the possession of cannabis is no longer based on a defined behavior that is considered to violate prevailing social norms, but rather it is criminalizing people based on age and timing. And this is what the court referred to as a status offense, where one is criminalized not because what they've done is, entirely a criminal offense, but rather the age at which they are doing that makes it a problem. So, then it jumps then into the, unfair discrimination on the basis of age. So now, and of course, when we made our submissions in the Constitutional Court, we did refer to the Prince case, and we said that the problem with what the Constitutional Court has done in the Prince case, when it legalized the use of Dagga for adults in their personal spaces, is that it left children in a very invidious position that they will continue to be prosecuted for a behavior or a conduct that is not otherwise criminal when it's done by other members of the society. And, it is very important, that, when we talk about children's rights, it's very important, to acknowledge that children are not only entitled to the rights which are listed in Section 28 of the Constitution, but rather that children are legitimate holders of all the rights, a majority of the rights which are in the Bill of Rights, unless those rights which specifically state that these rights may only be exercised by an adult or a person who is over the age of majority. So now, the provisions of Section 4 of the Drugs Act, it was found that it violated the right to equality, children's right to equality. It also violated children's rights to their best interest. And, the best interest of the child is not only a right, but it's a principle, and it is also a guiding principle. And it tells us as to how should we conduct ourselves, or how should processes run in matters that involve children. Then, of course, we also made submissions into the limitation clause to say, there are actually less restrictive means that you can deal with children who are found in possession of dagga or children who are using dagga. For example, there's the Prevention of Treatment for Substance Abuse Act. That act can also be utilized to respond properly in order to sort out, or in order to make sure that the protection of the children who are found in possession of dagga or children who are using dagga, that their best interest is kept at heart in all the matters. And most importantly, also, we do have the Children's Act 38 of 2005. And if one looks at the provisions of Section 150, there is a provision there that a child can be, a court can declare a child to be in need of care and protection if that child is addicted to any dependency producing substance. So basically, what is the Center for Child Law, what we are arguing is that there are less restrictive means that we can that can be used to address this issue, and those less restrictive means they are the appropriate ones to properly deal, and also to ensure that the best interest of the children is of paramount importance in all those matters that involve the children. So basically, the criminal justice system is not the appropriate system to deal with children who are found in possession of dagga, who are using dagga, and luckily the court, fortunately, as the foundation that was laid by Dr. Who spoke before me, that the trends of the Constitutional Court in dealing with matters that involve children or matters involving children's rights. Dr. Elvis, they correctly pointed out that the court has been taking a rather activist approach in ensuring the protection of the rights of children. So Tandega just told me that I have 5 minutes. I'm wrapping up now. So another case that I want to bring to the audience attention is the VJV case versus the Minister of Social Development, or the Department of Social Development. Now, this case, we are still awaiting judgment from the Constitutional Court. We made our representations sometime last year, and we were amicus in this case. And the bone of contention in this matter was Section 40, the provisions of Section 40, and Section 1, the provisions of Section 1 of the Children's Act. Now, the applicants approached the court to challenge the provisions of Section 40 of the Children's Act. It wants the court to find it unconstitutional to the extent that it does not include the word life partner, or the words a permanent life partner. And also in Section 1 of the Children's Act, they want the Constitutional Court to declare Section 1 of the Children's Act unconstitutional to the extent that the definition excludes any person who is biologically related to the child by reason only of being a gamete donor, or for purposes of artificial fertilization. Now, without just wasting time, let me just jump into the submissions that we made as amicus. So firstly, the Center for Child Law as amicus, we do agree with the applicants that the provisions of Section 40 is unconstitutional. However, where we differ with the applicants is that we do not agree that the unconstitutionality results from the provision being unfairly discriminatory against same-sex lesbian couples, because that is the argument of the applicants, that the provisions of Section 40 is unfairly discriminatory against same-sex lesbian couples. Now, we also made the submission that, you know, when one looks at the provisions of Section 1, which it defines the word parent, who constitute a parent and who does not constitute a parent of a child. So when one looks at the provisions of Section 1, you know, it serves an important purpose for ensuring that the gamete donor, in the strict sense of it, are excluded from laying any claim to the child. So this is to ensure that someone who goes into an agreement that they are going to be a gamete donor, either be an ovary or either be a sperm, that that person does not later on come back and claim that child as their own. That is the purpose of, you know, or that is the way in which Section 1 is worded when it comes to, you know, defining who constitutes a parent. So we also submitted that, you know, to simply delete the alleged offending provision without properly engaging as to reasons why the provision exists as it is, you know, it will undoubtedly open floodgates regarding the status of the gamete donors. As I said earlier, that a gamete donor, if this is entirely deleted, for example, Stanley, who donated a sperm in 2010, can later on, because of that provision, if it's found unconstitutional to the satisfaction of the applicants, Stanley can come back and claim a child and say, but this is my child, I don't care. At that time, yes, I was a gamete donor, but now I want to claim the child because the way in which the section has been amended allows me to do that. Now, finding the definition of the parent, of the word parent, as it is drafted in the Children's Act, to be inconsistent with the Constitution. You know, it excludes a person, it excludes these people, and it also limits the opening of floodgates for children to claim legitimate relationships with gamete donors. It's not only the parent who can come, the child also, you know, from a child-centered perspective. Once the child finds out that I'm a child who was conceived through artificial fertilization and the person before me could have been one of the gamete donors, if the deletion that the applicants want is granted, it opens floodgates to that for children to claim legitimate relationship with their gamete donors. And at that point in time, you find that the gamete donor does not have any intention to have a child. And by that, I mean that they do not have any intention to acquire parental responsibilities and rights. Yeah, that's it. Thanks, Tandega.
Thank you, Stanley. I think we know, as the name says, Center for Child Law, that you deal with child law matters. But I think that just by these two matters that you chose to discuss, you can see just how varied child law is and just how varied the matters that you are involved in are. So I was fortunate enough to have been clerking for Justice Nhlanhla when she wrote the judgment for Center for Child Law. And I think, yes, definitely one of the most important questions for the court then, as you can see, as reflected in the judgment, was to very adequately highlight and very explicitly say what the matter is not about before going on to discuss what the matter is about. And I do think that it was an important matter because it might be fair to say that Prince couldn't have dealt with it with the issue of children and the possession of marijuana, as well as the Center for Child Law matter did. And then also with the VJV matter, I know it was heard in the fourth term of last year, and we're eagerly awaiting the judgment there. But I do know that Justice Collip, in one of his last, it's not the first time something like this has come up, one of his last judgments in the Pretoria High Court before joining the Constitutional Court had facts which are similar to VJV. So unfortunately, that one boiled down to contractual law and not, child rights. But we'll see now that the Constitutional Court has been seized with it. We'll see how that goes. But yeah, we'll keep an eye out. Thank you very much, Stanley. Finally, we have Professor Amanda Boniface, who will be our last speaker for this evening. So Professor Boniface is an associate professor at the Department of Private Law at the University of Johannesburg. She's also an admitted advocate of the High Court, and her expertise are in the areas of child law, family law, as well as mediation. So thank you very much, Prof. Boniface. You can go ahead if you're ready.
Thank you. Some of what I'm going to discuss, the other speakers have touched on. So in that regard, those things I will just mention briefly. So the outline of my presentation is that I'm first of all just going to mention some important constitutional court decisions. Then I'm going to refer to South Africa's periodic country report to the African Committee on the Rights of the Child. And that was from June 2016 to March 2021. And when I look at that, I'll look at some achievements or highlights that we indicated in the report, and then also some challenges that South Africa experienced that were also mentioned in the report. And then to end with, I'm going to mention two aspects that our jurisprudence still needs to actually deal with in more detail. So firstly, the Constitutional Court decisions, I'll look at some from 2021 and 2022, and I'm just going to mention them very briefly because they have been mentioned, most of them already. The first one is the Center for Child Law versus the Director General, Department of Home Affairs, where the order was confirmed declaring Section 10, the Birth and Death Registration Act, to be unconstitutional. That was, of course, dealt with, and the importance there regarding not only the equality of unmarried fathers, which of course are important from a family law perspective, but also the importance that the best interests of the child as well as the dignity of children were stressed. I'm not going to go in detail there. If anybody is interested, I did write an article shortly before the Constitutional Court confirmed the Court opposed decision, and that is in the 2021 THRHR Volume 1, if anybody does want to read up further. But for the sake of time, I'm not going to mention that here. And then in another case, the drug case, or the possession of cannabis cases, was mentioned before. The Center for Child Law versus the Director General of Public Prosecutions, Johannesburg, and others. And that, of course, was, the criminalization of cannabis and whether it should, this should apply for children as well. And of course, happy to see there that the court said that no, this infringes the rights of the child and actually harms the child, as well as affecting best interests of the child. Right to dignity once more were grounds relied on. And then another more recent case, TM acting on behalf of MM versus the member of the Executive Council for Health and Social Development in Gauteng, which dealt with the right to prenatal care and the consequences for inadequate care for children. Now, this case I still want to study in more detail, but from what I can make out, the facts were that the child had cerebral palsy, which was caused as a result of an emergency C-section being delayed by the hospital and the doctors that should have been treating the woman. It was in a public hospital. Now, the Supreme Court of Appeal had said that, yes, there should be a duty of reasonable care. The medical doctors, etc., should have taken care. Therefore, the health and social development is also liable. Now, the Constitutional Court said there were issues, and the issues were not Constitutional Court related. They were related to not being able to prove causation as well as negligence. Of course, we all know if we're looking at a delict, the causation is of utmost importance. However, there was another matter here, and this is the matter that I still need to look at in more detail and study this case more and possibly write about it. And that is that they also approached the court saying that the problem was the allocation of resources. And due to this allocation of resources problem, this is what actually contributed to this whole scenario occurring. The Constitutional Court, however, said that it does not interfere with this. So it is not within its sphere to interfere with this. But to my mind, the question still remains then, doesn't this affect the right to dignity of children, in certain instances, right to life of children, etc. So that's something we can maybe think about and something that I will write about probably in the future. Let me just get to my second aspect that I want to look at, and that is the periodic country report and what South Africa reported on. Now, some of the positives included in this report, we must just bear in mind this was from June 2016 to March 2021. There was going to be the introduction of the Children's Amendment Bill, which we also thought was going to help with things such as abandonment of children, but I'm going to discuss that a little bit later in the presentation, the aspect of abandoned babies. Then the other positives were that the early childhood development programs functions were also moved from social development to basic education, which actually would make more sense. And then there was adoption of a 5-year national plan of action that was also put in as positive. And then South Africa also indicated that the best interests of the child continue to be the primary consideration in matters affecting children. And this included our response during COVID-19. So there were food relief programs given and social grants were implemented. We'll get to the negatives of that just now. And then, of course, the national policy framework regarding trafficking of persons was launched, and this had more of a victim-centered approach that occurred. Now, before I look at some of the positives, because a lot of these positives that I'm going to mention are more related to the provision of family law services. Let's just first look at some statistics. Now, these statistics I didn't find in the report, I found them in various other places. But in 2019, there were 23,710 reported divorces in South Africa. On average, we have about 4 out of 10 marriages in the last couple of years that end in divorce. This is usually between the 4th and the 9th year of marriage. That's sort of the dangerous period for a marriage as regards divorce. And in 2021, 56.6% of divorces involve children under the age of 18. So let's just bear those statistics in mind when we look at the positives of the report and assess, whether they should actually be still improved upon. So the family law services provided, and this was given as a positive in the report, were that 28,300 children benefited from family law services over the entire period of the report. So that's from 2016 to 2021. And then in non-litigation matters, so those are matters solved through mediation, conciliation, negotiation, family advocate is involved, etc. The target here was that 50% of those would be finalized in 6 months, and they did reach a target of 80%. So there was definitely improvement there. And then maintenance matters that were finalized within 90 days, there was 80%. The number of parenting plans registered, the target was 2,000, and they managed to register 4,200, which is a great improvement. However, if you look at the statistics of the number of divorces, I think more study is actually required here as to see whether we're actually meeting what we need to. And then the number of parental rights and responsibility agreements, they reached target, but target was only 1,214. And then the positive also was that the voice of the child is heard, and they stipulated that the voice of the child is heard via the family counselor, who works with the family advocates offices. Right, thirdly, what I want to look at is a couple of matters that still need to be dealt with by our court. As far as I'm aware, there isn't any constitutional court decision on this as yet. The first thing is regarding regulating and decriminalizing even the abandonment of babies. and using baby savers, sometimes referred to as baby saves, in this regard. My former doctoral candidate, who is actually on screen at the moment, Dr. Rosenberg wrote a doctoral thesis on this and has submitted a policy document which is currently before Parliament. And the important things she mentioned there, which tie in very well with what we're discussing today, is that the child's rights to life and right to human dignity are what are important here. So currently some other countries such as Namibia have got safer mechanisms in place, such as safe haven laws, etc. And South Africa is unfortunately still behind in that regard. So in this regard, you can have a look in the African Human Rights Law Journal of 2021 on page 938. Dr. Rosenberg wrote something on that there. I'm just going to refer to them quickly because I have been given my warning. And then you can also refer to what Dr. Rosenberg and myself wrote in the Journal of South African Law in 2019, volume 1, page 49. And you can also have a look at the Journal of Contemporary Roman Dutch Law 2017 on page 254, and that was volume 80. If you want to have a look at that. Of course, if anybody is interested in that policy document, I'm sure Dr. Rosenberg would also be more than willing to share that with you. So the last aspect that I just quickly want to touch on is that we still do not have one-stop family centers in South Africa. And by that, I mean a center where everything is dealt with in one place, in one stop. So divorce matters, contact, guardianship, all of that, domestic violence matters, maintenance matters, parenting plans by family advocates, mediation by mediators and family advocates, basically all matters affecting children, so that the presiding officers as well as mediators, etc., dealing with the parties have a complete picture of what is actually going on in this family, and also accessibility for people, access to justice, hearing the voice of the child is present, and obviously catering for the best interests of the child. Thank you.
Thank you, Prof, for that very, very informative segment. Just some notes or some points regarding the TM matter. So that matter was handed down while I was still at court. And I do know that that decision was, so the Supreme Court decision was split, right? And the majority, the dissent had the majority, and the dissent was penned by Justice Rogers, who was acting at the Supreme Court at that time. So just before TM, so TM was decided on the basis of the outcome on the NVM matter. NVM was, the scribe for NVM was Justice Majid, but Justice Rogers was acting at the Constitutional Court at that time, and he got the majority for his dissent. So Justice Rogers' decision in the, or dissent in the FDA for the TM matter is much like the decision in his dissent in NVM at the Constitutional Court. So TM really, I think that NVM is where the debate is, because TM really just followed the outcome of the NVM matter. And then with regard to the periodic report that was submitted to the African Committee of Experts as well, there's going to discuss it at the upcoming session. And I was also fortunate enough to be part of the secretariat of the commission committee when they were drafting the previous concluding observations for South Africa. And I haven't read the current state report in much detail, but one of the things that really popped out for me is just how much you know, the anxiety that the committee had regarding child marriage in South Africa, and how little has changed in that regard. You know, so we shall see in these upcoming, in the state report, and I guess the concluding observations, if there's any change there.
I actually forgot that point, that one of the recommendations was that all types of marriages for everybody should only be from 18, if I remember correctly. Yes, that's also a very important point.
Absolutely. Thank you, Prof. And then I also want to, Prof mentioned a bit about Dr. Holzenberg's doctoral thesis. So if Dr. Holzenberg, you would like to hop in and say anything regarding child abandonment and your policy or your research, please let us know, and you can hop in now.
Hi, thank you so much, Tandeka, and thank you to Prof. Boniface for sharing that information. I'll just briefly state that I am working on that document. Well, I've worked on that policy document for Parliament, and in that document, we are suggesting that safe relinquishment be legalized. So child abandonment will remain a criminal offense, but the safe relinquishment of an infant, we are asking for that to be legalized. Obviously to promote, as Prof has said, the right to life and the right to dignity of children. So that's all I'll add. Thank you so much.
Thank you, Dr. Holzenberg. We'll definitely keep an eye out for that policy as well. I, for one, didn't know that there was such a discussion happening in Parliament. And then we're going to go back to Stanley. Oh, if you have any questions, by the way, anyone, you can also wave and then or write it in the chat box. Professor Boniface had two questions, both directed at Stanley, but I guess all the panelists may chime in. The first one was regarding the new requirements by Department of Home Affairs that unmarried fathers have to, take a paternity test and provide the results in order to register their children's births. So it is a concern, the costs are a concern, right? And it is a concern that someone could simply register themselves as a parent without any proof of being a parent. How practically then does the panel think that Home Affairs should deal with this issue?
I'll take that one. And thanks, Prof, for that question. Even though it's difficult, but at the same time, very important. So, Prof, we are in the process of finalizing our papers to challenge the circular. And just to speak on the number of affidavits that we have from unmarried fathers who are still unable to register the birth of their children because of the circular, is that from the facts, Prof, number one, the thing that we see is that most of them are from rural areas. Most of them are unemployed, and a great number of them, the reason why, say they come to us for the assistance is that they want to place their children in school. So even though, Prof, we have the Phakamisa case, which says that lack of documentation should not be a barrier to a child to access basic education. Unfortunately, we still have those schools which are making it impossible for children who are undocumented to access basic education. So from the facts of the case, Prof, I can confidently say that from what we have on our desk, there's no parent who just wants to register the child even though the child is not their own. And also, Prof, with other offices of the Department of Home Affairs, the circular is not nationally being applied, Prof. There are other offices in the country where if a father comes and there's a doubt by the department that this is actually the father of the child, what they do is that they convene meetings and they call the father, they call the maternal, in cases especially, Prof, where the mother of the child has passed on. They would call the maternal side of the family, be it the aunt, the grandmother. They'd ask them to also come with, the death certificate of the mother. And the interview will be centered around whether the maternal side of the family actually knows this guy and whether they can confirm that the person who's actually making this application at DHA is actually the father. So there are other offices, Prof, which have found a way to sort of like assist unmarried fathers, because Prof, I think you'd appreciate that there is a provision, I think, in the Birth and Death Registrations Act, applying to children who were not born in hospitals. There are those rural areas where the hospital is like 100 kilometers away and a child was born. A mere affidavit can actually be provided to say that this child was born of this woman, this child was born in South Africa, and this is the father of the child, even though the child does not have what we call the road health chart, which is provided at the clinic when the child is born. So, Prof, from I do understand your concern, but from the facts that we have at the moment, Prof, there's nothing that suggests that there are fathers who just want to register children, even if they are not their biological children. They actually want to register them because lack of birth registration is actually, it is a barrier for these children to exercise other fundamental human rights.
Let me maybe add to what Stanley just said now is that we have to look at it in two ways. One, the first is the record, the statistics that we have in the country right now of children who are being groomed or who are in families without fathers. So there's quite a high rate of children who end up growing up with their mothers, and then the father is completely absent from the child's development. And from an international law perspective and from a South African law perspective as well, these are issues that are not encouraged, or at least the law, to the extent that it doesn't allow a child to be groomed by one parent, or because both parents do have ingredients to bring into the child's successful development. The other issue, though, is that in defense of the state, in a way, you might find that what the state is trying to prevent here, and not doing it, in my opinion, properly, as Stanley mentioned just now, is that the state is trying to, close gaps where criminals could take opportunities to circumvent the system within the country. We can't completely be oblivious to the fact that we are in a country where anyone could show up at any time to claim anything. So in some cases, you have these barriers that will provide, provide or mitigate some of these opportunist situations where someone could come up to claim a child. I particularly like one point that the judge made in that decision. It becomes counter development or counter let's say growth, or counter best interest of a child. If a child is placed in a situation where the child has to grow with someone that they do not relate with, or that do not find comfort with growing with. I remember very well that there was a case in Ireland. In that situation was the case of an adopted child. The child didn't want to move to go with that particular family that wanted to adopt the child, but the family fell in love with this child and wanted the child. What the judge did, and this of course plays out in Article 12 of the UNCRC, what the judge did was that the child couldn't speak. It was still a very young baby, but the judge had to learn the behavior and the attitude of that child in order to prevent the child from being adopted by that family, because the child didn't feel comfortable in that space. What I would suggest to the panel and to those of us who interact with these issues on a daily basis is that we should find ways of assisting Home Affairs, because Home Affairs, if you read the laws, you see there are so many laws. Home Affairs is in trouble. Home Affairs has limitations of interpreting most of the laws and understanding most of the laws in South Africa. We should bring suggestions or recommendations that will help Home Affairs, mitigate its fears and also ensure that they protect or better protect the rights of children in the country. Thank you.
Thank you, Stanley, and thank you, Dr. Fokala. So Prof. Wilkes had another question, which was relating to the definition of parent, and it's aimed at the whole panel again. So how does the panel think that the notion of parent should be defined, and what role does gamete donation have, or should it play? No role.
I'm sorry, can I just go back to the first question? Was there
Yes,
not a recommendation in one of the reports that the DNA testing should be done away with? I think it was for foreign fathers. Or am I mistaken? I do remember reading this in one of the reports.
You see, Prof, that's one of the ways that it could do that. It could waive the fee, completely waive the fee. Because the idea behind the DNA test is not about the fee. The idea is to prove paternity. So if the objective is to prove paternity, the fee then becomes a hindrance, or the fee becomes blocks.
Okay, so the recommendation then was actually related to then doing away with any fee regarding such testing.
Yes.
Okay. Okay. Now that just puts it in more perspective for me. You know, I have not studied that report in detail.
But because if you look at it, the fee is the objective, the bottom line objective in this case, you know, was to ensure that unmarried fathers, you know, that they play an active role in a child's life. So you have to register the child and then be present in the child's life. Now, the introduction of a fee to prove DNA, the DNA is not a problem. The DNA is a good, you know, suggestion by or procedure by Home Affairs, but the fee becomes then a hindrance between the objective of the decision or the rationale behind allowing unmarried fathers to prove paternity and the DNA, which is of course a legal way of proving paternity. So if that fee is completely taken out of the way, we will have a better.
I agree there definitely. While I'm on, regarding the definition of parent, all I can say is it's far more complicated than what it at first might appear to be. And I don't think it's something that I would like to say, you know, what the definition would be immediately. And I think there's a lot of study that needs to go in. However, if we're going to say a gamete donor is a parent, we are going to open up a huge can of worms. And it really is, I don't believe is going to be in the best interest of the child, generally speaking, because, you know, there are other ways that a gamete donor can approach a court and, you know, say, I am an interested person and I've been involved in a child's life. Perhaps it was some sort of, you know, open type of surrogacy. You know, then it's different. But just to be an anonymous donor that now suddenly comes in and wants to be parent, that definitely I do not think is going to work. I'm sure the colleagues also have their opinions in that regard.
So if I may, Thandeka, with your permission, just to say, I attempted this definition in a paper that I wrote in 2019, right? Now, this is what you have to, I looked at it, you know, from a perspective where we have the original understanding of who a parent is, that this is the biological father. But we live in a world that is more open and to many other things like the donors and all whatnot. We need to look at it a little bit differently. And the two different ways that one could look at it now is the fact that one, you have the African cultural way of looking at this, where a parent is not necessarily the biological parent. You know, it goes through that saying, and we all know this, you know, a child could be born from two people or from adopted by two people, but the child is raised by the community. Now, you have that, and that is why the Children's Rights Act, or the Children's Rights Act of 2005 that we have.
Children's Act, yeah.
Children's Act, Children's Rights Act, sorry. The Children's Act, the Children's Act of 2005, if you see the way it defines a parent, you know, it goes beyond the biological parents. It goes beyond the biological parents to look at those who are around the child or those who raise the child. Within international law framework, as you all know, is that the international law framework is not, and the same with the South African Children's Rights Framework, it is not interested in who the father is. What the law is interested in is that a child should be raised in an environment that is conducive to the well-being of the child. So irrespective of who the father or the mother or the parents are, but who is responsible at the particular time to bring up a child and to be the first point of call or the primary caregiver of a child when the child needs help would be regarded as the parent or as the guardian of the child.
No, that's, if I may, Thandeka, just to add, you know, I think just for the benefit of our audience, you know, the definition of parent as it currently stands in the Children's Act is that, you know, it includes an adoptive parent, but it excludes 3 categories of persons. So the first category is a biological father of a child who was conceived through rape or incest. Then the second one, that is the bone of contention in the VJV case, that any person who's biologically related to a child by reason only of being a gamete donor for purposes of artificial fertilization. So it is very clear that when you are a gamete donor only for purposes of artificial fertilization, you cannot be regarded as a parent. And lastly, it excludes any parent whose parental responsibilities and rights have been terminated in terms of this act. So really, it just has three categories. And in the VJV case, the bone of contention was the middle one, to say that if you are a gamete donor only for purposes of artificial fertilization, you cannot come and claim parenthood in terms of that child. Yeah.
Thank you. Yes, this is a debate that's happening all over the world, I think. Some countries have moved towards what Prof. Boniface says would not be in the best interest of the child, and some countries are still, on the same footing as South Africa. And it's just unfortunate that the name of the case now escapes me. I actually tried to look for it while Stanley was talking. The one that Justice Collipin handed down at the High Court. But there was that one was not published, I think. But what I do know is that this was a matter dealt with in terms of contractual law. And so we're thankful at least that in VJV, they will have to discuss the matter in the light of, children's rights. So we'll see what the court says about that. Just to go back to the matter about, unmarried fathers once again, someone was asking here, to take away the DNA fee, is it not possible for the government to provide the DNA services? So perhaps, Stanley, you can answer on the possibility of this, as well as maybe just give us some tidbits regarding your report that you're writing or the work that you're doing in relation to, this circular that said that there must be DNA testing.
Thanks, Thandeka. Look, I think, that the answer is very straightforward. And I think Prof. Boniface and Dr. Elvis have also discussed this in terms of the recommendation that the problem is the fee, and the fee should be waived away. If the main point is to ensure that these children are registered, and if there's any question when it comes to the paternity, then the fee should be waived. Because in the, I can tell you, Thandeka, that in some of the cases that we do have, we actually do have those fathers who have the financial means to do the DNA test, and they've actually done it. Those who are able to do it, they've done it and they've paid for it, and they've gotten the birth of their children registered. And in South Africa, when we talk about access to fundamental human rights, the moment we start limiting access to fundamental rights to the monetary position of a person, we are actually making a big mistake, especially in a country that has a very huge gap of inequality. So we shouldn't allow Home Affairs to make that mistake that you can only register the birth of your child provided you can pay 3,000 for 3,500 for DNA fees. So basically what we are saying, basically what the Home Affairs will be saying is that as a child, your father must have 3,500 in order for you to have access to other fundamental human rights. Because, without a birth registration, there's a lot of issues. As I'm sitting now, I actually spoke to a colleague from Cape Town, and they sent me an email and screenshots of the system for admission to public primary schools in Cape Town. The system, the online system, still requires a birth certificate, and it requires also a study permit. I mean, that was the first time I see that, wow, for primary school, you need a study permit. And without uploading those documents, you can't even move. Like, you can't press next. The area is gray. So yes, definitely, the fee must be waived. The fee must be waived. And, our approach also as the Center for Child Law is that he who alleges must prove. If Home Affairs says I'm not the father, let them pay for the DNA test. Then I'll submit myself to it. The problem is that I do not have the money to submit, to pay for it. That's just the honest truth. And that's the trend of the cases, that we have. So it's more a matter of having the means, the monetary means to pay for it. Not that the people don't want to do the DNA testing. They would love to do it at all costs.
Okay, thank you very much, Stanley. There was one other question, but it has been answered. It's on abandonment. Is the proposal from Dr. Rosenberg mentioned by Prof. Boniface that the state will take care, will take charge of children who are safely handed to the state and be available for adoption? Does the state have this capacity? Will the biological father-mother have any residual rights? So Dr. Rosenberg did respond saying that the current practice is that existing CYCCs, which I think is Child and Youth Care Centers, takes these children in, and the normal rules regarding termination of parental responsibilities and rights apply. Parents have 60 days to reclaim the child, failing which the child is made adoptable. I also just want to follow up, if I may, either Dr. Rosenberg or Prof. Boniface. I recently saw just randomly on Facebook that there is a family or a couple in Namibia who have like an abandoned child drop box at their house, basically. So it's not the state taking the children into their care, but rather, you know, private citizens who have decided, is this something that has been considered for South Africa as well? Is this something that would be safe to do in South Africa, or something that we would propose in South Africa as well? I'm especially asking this because considering just how our adoption processes or system is in shambles, you know, and there are also issues with regard to the state caring for children. So thank you, Prof.
Dr. Rosenberg can add to this, I think. I just want to mention that there are already places in South Africa that have baby savers. What we want to do, and what Dr. Rosenberg is proposing, is that this is actually regulated, and that we also have baby safe havens as well, such as what is present now in Namibia and a number of other countries. But I think she can add on a little bit if we have time.
I can just add a little bit to that. We currently, like Prof has said, we do have organizations, private organizations that have baby boxes attached to their walls, but these organizations have a working agreement with child protection organization. They must. So for example, if a specific home wants to have a baby saver box and take in abandoned children, they must be registered either as a CYCC with a working agreement with a child and child welfare, or another example would be ABBA, child protection. They have to have a working agreement with them in order to receive these children, and in order to have the necessary processes in place, because then a social worker will take the process over and will do all the necessary steps like they do with all other children.
Okay. Thank you, Prof. Boniface, and thank you, Dr. Rosenberg. As there are no more questions, I'm just going to close our session here and thank. Okay.
Sorry, Thandeka. I think before you close, I forgot to address one of the the most important questions that I think you posed in the concept note. Whether the Child Justice Act, adequately protects, the rights of children and the best interests of the child. I think just by way of example, Thandeka, I can say yes, it does. If one looks at the provisions of Section 58 of the Child Justice Act, it makes provision for diversion, and we know that in that in those provisions, there are certain offenses that when committed, diversion should be like the first option, because the main point is to treat this person as a child, is to look at their age, their level of maturity, and also their development and, their position in society. So the Child Justice Act, although it is, it deals with children in conflict with the law, it doesn't treat them at the first glance as children who are in conflict with the law. It treats them as children first, and as people who are capable of grabbing on to a second chance in life. Then, just in relation to the Dagga case, you'd recall that those children were actually on diversion. They were given 3 months diversion. All of them, they didn't comply with the diversion order, and that's why they were sentenced to indefinite imprisonment or compulsory residence at a child and youth care center. So the provisions of Section 58 actually tell us that where a child has failed to comply with the diversion order, the first approach is that, that child must be summoned back to the Child Justice Court. It's either they are summoned or it's either a warrant of their arrest is issued so that they can be brought back. Then when they are brought back, it's not an outward punishment. What the provisions of Section 58 actually says that there must be another inquiry, and that inquiry must actually try to find out what are the reasons that the child failed to comply with the diversion order. Then in that inquiry, the presiding officer also makes a finding as to whose fault is it. Is it the fault of the child, or is it the fault of the caregiver or the parent, whichever case may be? And where, even if it is the fault of the child, resulting in the failure to comply with the diversion order, it's not like, okay, the child has failed and we are going to lock you up. The magistrate must actually make an inquiry whether do we change the conditions of the diversion order which the child failed to comply with, or do we change them so that we give this child an opportunity to try and comply, because the whole purpose of a diversion is to try and assist this child, so that they can be completely diverted away from the criminal justice system. And just as an ending also, if one has a look at Section 76, that's the sentence it provides for sentencing. And it will tell you that, where a child is sentenced to compulsory residence to a child and youth care center, the provisions of Section 76, it actually makes reference to Section 191 of the Children's Act. So for me, in my view, the way in which the Child Justice Act, being a legislative body which regulates the criminal justice system insofar as it relates to children, for the mere fact that it goes as far as referring to another piece of legislation which talks about the care and well-being of children, or rather safeguards that, being the Children's Act, it shows that even within the criminal justice system, the Child Justice Act does take into cognizance that we are dealing with the child and that their best interests are of paramount importance, that even if they are sentenced to imprisonment or compulsory residence, that sentence in its own must take into account their best interest, their level of age, and their placement. And it also, this Section 76, it speaks also about the type of programs that this child must attend, because the entire idea behind the Child Justice Act is to rehabilitate and completely divert the child away from the criminal justice system, so that this child becomes, a valuable contributing member of society, just as opposed to just being labeled as a criminal and being left there. So yes, Thandeka, I would say, confidently that the Child Justice Act does actually, take into account the best interest of the child. And lastly, Section 85 of the Child Justice Act, it tells us that where a child is sentenced to imprisonment or compulsory residence, that sentence on its own is subject to automatic review. So you see, it is very important that when a child is incarcerated, that sentence that says incarceration is subject to automatic review, so that a higher court can actually gauge as to whether was that sentence made in consideration of the best interest of the child and the rights of the child that is involved in the matter. So indeed, it does, cover that.
Okay, thank you very much, Stanley. Wow, thank you so much. And thank you to all three speakers. Just in closing, I want to pose one final question, throw it to all three of you. In the light of recent, the trend in, if we can call it a trend, in the Constitutional Court's judgments generally, they're in all sorts of directions, but also with specific regard to children's rights and, child law. Looking, for example, at how the cases of NVM and TM are on the opposite side of the room compared to the matters that Dr. Fokala mentioned earlier on, and matters such as Center for Child Law, and which really take into consideration the best interests of the child and the child's position. So what do we think are the next steps? Where do we think that things are going to go, or where do we think that things should go for child law or children's rights in South Africa and perhaps the continent at large?
I can just try and give try to answer that. You know, Tandeka, I guess, you know, this is one thing that some of the things rather that Professor Anne Skelton has been stressing, and I think she also provided a brilliant article on this, you know, whether the judiciary is whether there's an over-reliance on Section 28 of the Constitution. So for me, I would say the direction that I'd want to take the judiciary, to see the judiciary take, is less of a reliance on Section 28 and actually a recognition that children also hold other fundamental human rights. So I would want to see, you know, a judicial decision that sticks maybe on the right to human dignity of a child and how that right should be protected and how that, you know, that right should be expanded. Because, and I'm saying this, Tandega, because, you know, we are sitting here, Human Rights Month, there's been, you know, a court order in relation to pit latrine toilets, and we are sitting here and a 4-year-old that is just, a 4-year-old died in a pit latrine toilet in a school. So I'd want to see a judgment that speaks to the right to human dignity of a child in relation to their right to basic education. We cannot, you know, allow a situation where a child attends or receives a basic human right while their life is in danger. How do we balance the two? So I would like to see a bit of moving away, not really a moving away, but a less over-reliance on the best interest of the child. That's there. I think that song has been sang very loudly. We all understand it, and it has been built very firmly. But there are other rights that children are entitled to that, for me, they have not been given that recognition.
If I may, so for me, one of the things that happens in most of these cases is that children's rights issues are one of the most contentious issues. It's also one of the most sentimental issues that we deal with. It is also something that, in terms of parental responsibility, comes with a heightened level of possession. You know, parents become very possessive. We all love kids. We all want to see kids grow. So when a matter goes to court, in our brains, we already think we know where the decision should be. It should be in favor of the child. And where I'm going to here is the fact that in most cases that the court has decided, whether they're on the left or on the right, is that the court has tried to balance what is in the best interest of the child. And what I've defined in most cases about this issue of best interest of the child is that it's a double-edged sword. It can cut on both directions. But what is important at the end of the day is that whatever decision that the court arrives at, it should be in that child's best interest and no one else. If the court passes a decision that says a child should not be incarcerated, or that a child should be placed, you know, with a family that the court thinks, after consultations and using social workers, that the child will have a conducive environment, an environment that has love and care and all what the law provides, the law can pass those decisions. I've seen decisions where the court has taken away a child from its biological parents to give it over to a secondary parent. And this is because the law thought after, or the courts, after evaluation of all the heads of argument, that the current environment in which the child was, even though these are the biological parents of the child, it wasn't conducive for the child. It wasn't the best interest of this child, and that this other family would be able to do that. So that thread, for me, needs to continue. It needs to continue whether we are, as people or onlookers, happy with that or not, but it needs to continue because the child should always be the primary subject, and that best interest should always be the paramount decider in that case. Thank you.
Thank you very much, Dr. Fokala. Just to make sure, Professor Boniface, would you like to answer as well?
I just want to agree there that from what I've seen, definitely still best interest of the child is paramount at the forefront of the court's decisions. However, they are mentioning things such as right to dignity, etc., in many of the decisions. So I think we're looking at a very more rounded approach that is happening currently. But of course, best interest of the child, does always remain the primary consideration.
Thank you so much, Prof. Thank you so much once again to all three of our speakers. And yeah, we hope that you enjoy your evening, and thank you to everyone. Bye.
And thank you to SciFac, and thank you to Prof. Birgit as well.
Thank you.
Thank you from my side to everyone, and much appreciated. Thank you for a wonderful discussion. Good evening, everyone. Good night.
Thank you. Good evening. Bye-bye.
Thank you.